Good afternoon to you all. Welcome to the latest in the Farrar's Building webinar series. Our series is now into its 8th month, and I'm pleased to say that it's seen Farrar's shortlisted for Marketing Campaign of the Year in the Personal Injury Awards. All the prior talks as a point of interest remain available on the Farrar's Building website. And for the purpose of today, my name, for those who don't know me, is Michael Doherty. I am a barrister and tenant at Farrar's Building. I have a practice that includes fast track and multi-track personal injury and clinical negligence. And today I'm going to talk to you about the topic of secondary victims. I'm going to do so with reference to the recent or relatively recent decisions in Paul and Wolverhampton, which, as I understand it, are presently the subject of an application to appeal. The format is as is shown to you on the slide here. I will talk to you about a general review of the secondary victim control mechanisms. And I say that's important to do in matters such as these to provide the foundation for analysis. One finds the judgments in this area very commonly frame themselves by reference to that groundwork. We'll look at the respective decisions of Master Cook and of Mr. Justice Chamberlain in Paul and Wolverhampton. We'll have a look at some of the key factors in which decision might be preferable and those authorities that cause conflict in the area, as well as a little discussion about the way forward and a view on accident versus clinical settings, as well as what I think is the central question in this particular matter, which is what is the index event? One should say this is a complex, it's a notoriously challenging area of the law. There's also a good amount to get through to cover those things that are on the slide there. And hopefully I can do it some degree of justice in the hour or thereabouts for which we are scheduled today. And hopefully also pitch it at a level that provides something for all of those watching to think about and take away. It is an area of law which is, and I think will continue to be, the subject of debate and a certain degree of angst. What that does mean is that while I welcome questions, and there's a Q&A facility that those of you who are familiar with Zoom will doubtless be readily able to use, those questions are welcome. It may be that time, or it may be that complexity allied with time, limits the chance to respond to all of those. However, I remain willing to receive questions or undertake discussion, which is after all what a lot of this is, via chambers after the seminar. There's also slides that will come out to those who are attending today, which have my email address on. So moving on then to the main content of the talk. The title of the talk contains a familiar quote, "Thus far and no further," which you'll doubtless recall from the Hillborough tragedy-related case of Frost. It was said the only prudent course is to treat the pragmatic categories as reflected in the authoritative decisions such as Alcock as settled for the time being, leave any expansion or development to Parliament. And the Law Commission looked at this in 1999 and nothing further was taken. Lord Hoffman's perspective in that same case was that the search for principle was called off in Alcock. But as I said before, it's sensible to consider where the law was at that time, how it got there, and what prevents further development. As I say, many of the cases consider that in the preface to the judgments. Looking then to the control measures themselves, the process of identifying an eligible secondary victim claimant might perhaps be distilled, as I suggest there, to who, where, when, and how. That uses the analysis of Lord Ackner in Alcock. The who there, the class of person, and that class of person by reference to their relationship with the primary victim of the tort. The where and when, drawn out of proximity in time and space to the accident affecting a primary victim. And we'll see today how the notion of accident may be an interesting one to alight on. And the how, the means by which the shock is caused or experienced. Of those, the second is the most relevant for the purposes of today, specifically the question of the accident, whether the incident arises from an accident, something more generally termed as an incident, an act, or an omission. It seems to me and this talk will develop the point that that distillation on the screen calls for a more granular investigation of, if I can put it this way, the what to which the where and when attaches. Is the tort comprised of one or more part or stage? And if so, which of the stages is the event? And that is in no small part the issue in the case of Paul that we will look at. I've also placed on the bottom of the slide there the words proximity, accident, event, and immediately, because to me, labelling is a topical issue in these matters. Factual and legal analysis often engages overlapping considerations on which similar or identical labels can often be applied, in particular those on the screen. And I'll turn in a moment to briefly draw together the threads from those labels in reflecting the settled law in this area. I also pause to say that at all times when doing so, we ought to keep in mind that claims arising from negligence in different settings can have a different factual character or quality. For today's purposes, that might be a typical accident, quote unquote, specifically all arising and concluding in an instant, or from an incident or injury occurring as a result of an earlier breach of duty, whether that is by act, omission on the part of a tortfeasor. So as to proximity and immediacy, tort law has long recognised the neighbour principle to identify the range of persons. We're all familiar with that. Proximity between the defendant and the claimant, which for a moment I pause and say for our purposes today, the primary victim in a tort. And it's helpful to remember that quote: one who is so closely and directly affected by my act, I ought reasonably to have them in contemplation as being so affected when directing my mind to the acts or omissions. Now, in respect of secondary victim claims, further proximity requirements extend variously. They start with the requirement for that above sufficient relationship of proximity between the defendant and the primary victim. They also require sufficient proximity between the defendant and the secondary victim. And that derives from the House of Lords cases of McLaughlin and O'Brien, from Alcock and Chief Constable of South Yorkshire Police, and as I might term it, locked down by the case of Frost, thus far and no further. And that further proximity, as you'll know, is comprised, as per Lord Oliver, of first, proximity between the primary victim and the secondary victim, that close tie of love and affection. And second, proximity between the secondary victim, the party suffering the psychiatric injury, and the defendant, and that furnished at least in part by physical proximity to an event, and I place that in quotes, temporal proximity to an event. And I pause there to note that Lord Oliver, in arriving at that proximity pairing, those two requirements there, relied upon Lord Wilberforce and McLaughlin. As regards proximity to the accident, it is obvious that this must be in both time and space. The shock must come through sight or hearing of the event or of its immediate aftermath. And then there is also the how, the means, the sudden direct visual impression on the secondary victim's mind of actually witnessing the event or the immediate aftermath of the event. So I alight on the word event, and what can we say of event at this stage? Well, I think what's clear from the words used by Lords Oliver and Wilberforce is that there's a requirement for proximity to an event. Now, in those cases that those judges were considering, the contemplated matters were what one might call accident related. They were a vehicle crash on the one hand and a tragic stadium disaster on the other, rather than a clinical setting. However, I look today at the identification of relevant events in each. But the common law therefore developed to the thus far and no further stage through the prism of coincidence or proximity in time of each of a breach of duty and the incident contemplated as the event for the purpose of giving rise to the secondary victim's nervous shock. I suggest even at Hillsborough, where not a road traffic accident, obviously, no one was necessarily contemplating a time lag from planning to operation of stadium management and the breach at that time. Now, in the case of Paul and Wolverhampton, two daughters directly witnessed the shocking event of their father's heart attack months after the negligence. And that notion of event was a central feature, and in my assessment will continue to be a central feature in the case, which is likely to continue in one forum or another. And we'll look at that shortly. Before doing so, it's right to say there have been cases in the High Court and in the Court of Appeal dealing with the secondary victim concepts through the prism of negligence arising in whole or in part in a clinical setting, where in principle that makes the breach, the negligent breach, separable from the effect in time, and which may have a different character or a different quality than one in an accident. There are five in particular which I touch on through discussion today that were considered in Paul, and I touch briefly on them now for those who aren't broadly familiar. Taylor and Somerset, a High Court case, the judgment of Mr. Justice Old, had similar facts to the case of Paul that we're going to look at. Mr. Taylor died from a heart attack. That was consequent upon the defendant's failure months previously to diagnose heart disease. But Mrs. Taylor didn't witness the heart attack. Rather, she arrived at the hospital around about an hour later, and she was informed of the death at that point and went to the mortuary to identify the body and to confirm the truth of the news. And there was no recovery for the secondary victim. It was a culmination of disease, Mr. Justice Old said, not a shocking event in and of itself. Taylor and Novo, a Court of Appeal case, the leading judgment there by Lord Dyson, Master of the Rolls, that approved Taylor and Somerset, but slightly different factual tapestry. Mrs. Taylor, in that case, was involved in an accident at work caused by some poorly stacked racking. She was thought to be recovering, but 3 weeks later, she suddenly collapsed and died, a pulmonary embolism from a deep vein thrombosis derived from the accident. There was no recovery in that case on the basis that the negligence had two consequences, the accident and the death, and the secondary victim needed to witness the accident and thus was not at the scene of the tort, as it was put. Shorter is a death from a subarachnoid hemorrhage from an aneurysm. The negligence was a failure to observe properly a scan, which was reported at normal, and death occurred a week later. The secondary victim claimant, the primary victim's sister, made a claim, but she was not present at first instance. She was present at the scan review and also from shortly after arrival at the specialist unit. There was no recovery there. It wasn't a single seamless event, as we'll discuss briefly with Walters. It was seen to be a series of different effects through that period of time, a gradual accumulation on the mind of the secondary victim. There's the case of Renane, a negligent hysterectomy, where the secondary victim husband observed his wife connected to machinery for surgery and ventilated post-surgery, badly swollen, and there was no recovery. It was seen as far short of a horrifying event, and again, not a seamless tale of events. His perception was informed by prior information. And in North Glamorgan and Walters, and perhaps the outlier, as one might term it in those cases, the secondary victim did recover in circumstances where a 10-month-old baby was subject of a mistaken diagnosis. He, in fact, had hepatitis acutely. And if that had been properly diagnosed a week before death, he would have been given a transplant and probably would have survived. As it happened, he was readmitted to hospital. Mum awoke to witness a fit, and over the following 36 hours, 3 distinct events were seen as each sudden and unexpected assaults on the mind. But what that tells us from those 5 cases is that a claim by a secondary victim in a clinical setting is not without its difficulties, perhaps, as a first point. The Dryden and Johnson Maffei case at the bottom there, Supreme Court case that I'll touch on later, but is actually a separate principle that non-negligible damage is in fact actionable. And again, I'll deal with that later. So with that in mind, we have a set of control measures, and perhaps those cases briefly show some of those difficulties inherent. On that basis, I propose then to turn to the case of Paul and Wolverhampton. And with Paul, it's important to recognise that this is a matter arising out of clinical negligence that was heard in the context of an application by the defendant for strikeout or summary judgment and the alternative. And in consequence of that, as you'll be aware, all the facts are, of course, presumed on the claimant's pleaded case. The relevant pleaded facts were a breach of duty in failures to diagnose cardiac symptoms in November 2012. It was accepted had angiography been arranged, coronary artery disease was almost certain to have been shown. Death in January 2014 was in shocking circumstances, witnessed by two daughters aged 9 and 12, and those daughters had not been present in 2012 at breach of duty. For reasons that will hopefully become apparent within the flow of analysis, it's helpful to take a brief view of the arguments and also of the judgments latterly in each of the application and appeal hearings before taking a deeper dive into matters. The arguments broadly across the two hearings are on the slide there. For the defendant, the applicant, at first instance, it was said there was no relevant event. There was no proximity between the secondary victims witnessing matters in January 2014 and the breach of duty, the defendant, in 2012. It was said the claimants were absent from the scene of the tort, which completed, they said, when there was no angiography. It was said to be unable to distinguish from the cases of Taylor and Somerset and Taylor and Novo that we touched on a moment ago. It was said that the relevant event, as in Taylor and Novo, is the accident, not the later consequence, and accordingly applied in this matter. And some damage is actionable even where symptomless, so that some damage had been accruing between November and January 2014. The claimant's submissions were based around initially and largely the pleaded case, and that was that the heart attack was the first manifestation of damage, the first manifestation flowing from the negligent act. The claimants also said that there was no need to establish any temporal proximity between the negligence and the shocking event. The proximity in that respect, which is required, is between the secondary victim and the shocking event. And Walters was relied upon to the effect that negligence and the event can be separate events. Now, this is quite a busy slide, but we'll work through it. The two judgments, or the principal points of the judgments, are on the slide there. Master Cook, at first instance, struck out the claims, and he said that the correct control measure is proximity. That was the label. He said the question is whether the death was the relevant event, and I'll focus on that more a little later. He agreed that the matter couldn't be sensibly distinguished from the Taylor and Somerset and A Novo cases. And in the main substance of his judgment, which I'll talk about a little more, he said that the focus of death as the first manifestation overlooks the need for a proximate connection between the initial negligence and the shocking event. He said it was that proximity in space and time that allowed Alcock to impose a duty, and he said it was the lack of that proximity which defeated the Somerset Taylor Novo cases. It essentially said the separation in time and space between death and the negligence means the death just cannot be the relevant event. And again, we'll come back and consider that. Mr. Justice Chamberlain allowed the appeal, and it is this judgment which has generated the greater debate or controversy, depending upon your view. And principally, he said that the control mechanisms are fixed at macro level, that the control mechanisms coming from the House of Lords are fixed, but there are factual matters at a micro level which are open to decide whether those are satisfied on discrete facts. He said proximity has two operating principles. One is a broad principle, the neighbour principle in Donoghue and Stevenson, and one is a narrow principle of proximity, being the secondary victim controls. And he said it's those in secondary victim claims that are satisfied or not by the control mechanisms. He considered whether there was any requirement for negligence to be synchronous with the event, and his answer was no, and that seems to me, for the reasons said a moment ago, to be the premise of Master Cook's decision at first instance. And in dealing with the absence of the secondary victim claimants from the scene of the tort, Mr. Justice Chamberlain said, well, given there's no need for synchronicity, the scene of the accident tort is a scene of the negligence, but this is better recognised globally as where did the damage first occur. So he consequently held, and again important to recognise on the facts pleaded given the procedural stage, that this was a single sudden event, horrifying to children. And he said, as is there on the slide, in a case where such an event is the first occasion on which damage is caused, and therefore the first occasion on which it can be said that the cause of action is complete, Taylor and de novo does not preclude liability. And that gives rise to some areas of discussion, because in principle then, the principle upon which Master Cook exercised his direction seems in short to be to identify that the event relied upon was 14 months after the negligence, and to say there is an absence of proximity in space and time between those two matters, therefore the claim fails. Mr. Justice Chamberlain felt he had scope to operate within the areas of micro considerations, and he felt that the proximity, again, as we can see there, was not necessary between those two matters. So it gives rise to areas of discussion, which are micro and macro, broad and narrow proximity is dealt with there. The identification of the relevant event, which again I say is a feature that one comes back to, and whether that event, that identification time is the completion of the relevant tort. So dealing first with the macro and micro point, again, Master Chamberlain says macro, that's those which are fixed. The court can determine on given facts the micro points, and that a court is bound by precedent essentially if things are already determined on the index facts prior to that case, but otherwise he's unconstrained in the ordinary way. Well, I say in many respects that must be correct, but potentially does little more at that time than restate principles of legal precedent. The difficulty is whether Mr. Justice Chamberlain strays into the macro level, that is, whether the identification of the event is already settled at a macro level, or whether it remains alive at a micro level. And there's no doubt that can be a rather circular consideration. It is right that Taylor and Novo suggest that the proper focus is proximity between the secondary victim and the defendant. It being said in that case that it was wrong to elevate proximity to a relevant event to be the proper test. But that said, if the absence of the secondary victim from the negligent breach of duty is not a de facto bar to recovery, i.e. the aftermath principle, and if it be recognised with the negligent breach of duty is, or certainly can be, the defendant's only involvement in the tort, surely it follows that it need not be point-to-point or toe-to-toe proximity between the secondary victim and the defendant. Then query what is or are the occurrences, the happenings, the occasions to which the secondary victim must be proximate in time and space. In other words, what is the event on the facts? So the identification of the event must have had a relevant role in assessing Lord Dyson's principal question of proximity between the secondary victim and the defendant. As to the linked principle of breadth and narrowness, it was expressed in Alcock that the requirement for broad proximity operated between the primary victim and the defendant. That is where the neighbour principle was. And that once the secondary victim has a proximate relationship with the primary victim, the proximity to the secondary victim is to be found in the narrower sense of satisfying the control mechanisms. And I note that at paragraph 28 of the A Novo case, it was said, I accept the submission that the correct question is whether Miss Taylor, the secondary victim, and Novo were in a relationship of proximity in the legal sense. The difficulty in answering this question is that, as Lord Oliver said, the concept of proximity depends more on the court's perception, which seems to me to speak to the micro level, the court's perception of what is the reasonable area. In the context of claims by secondary victims, the control mechanisms are the judicial response to how this area should be identified. Now, if that position is adopted, surely then the road may, in fact, lead back to a somewhat different question, which might be, is there a sufficient relationship of proximity between the primary victim and the defendant? And it must follow that causation of injury to the primary victim has been resolved at that stage, although I'll touch on that further momentarily. Then, is there a sufficient relationship of proximity between the primary victim and the secondary victim, a close tie? And third, is there sufficient proximity in time and space between the secondary victim and the event so as to attain the requisite proximity to the negligent party? And if that's right, where is and what is the event? Touching there on the causation point, Mr. Justice Chamberlain recognised Lord Wilberforce's formulation contemplated causation from the fact and consequence of the defendant's negligence, and the control measures are applied after causation is established. And Lord Wilberforce's quote, the fact and consequence, seems to me to make clear there are distinct aspects of the negligence. The fact of negligence very often gives rise to no consequence. It's only with the consequence that actionable damage arises. And it seems to me to be right that absent damage, loss and causation, there is no resort to the control mechanisms. There's no apparent need for a defendant, or indeed perhaps primary or secondary victim, at the time of the event to perceive or appreciate the fact of causation by prior negligence. If that was so, perhaps the Hillsborough claims would inevitably not succeed. As to foreseeability, Lord Wilberforce again in McLaughlin identified that foreseeability, the prism, is the hypothetical person looking with hindsight at an event which has occurred. Master Justice Chamberlain felt it entirely foreseeable that failure to diagnose a heart condition could lead to a heart attack, and it to be eminently foreseeable that such an event could be sudden, shocking, and impactful on attending family members. So in those regards, you have to know what the event is in order to assess foreseeability, even if not operating through such hindsight. So again, to my mind, the recurrent gap is the identification of the relevant event. Now, in order to identify the relevant event and perhaps contemplate the distinguishability or otherwise of Taylor and Somerset and the application or disapplication of Taylor and Novo, and they seem to me to be the two cases most difficult to square with Chamberlain, along perhaps with Dryden, that we'll come to. I recognise I'm maintaining a course that the event is the central question, but at least in that respect, I'm not alone. Master Justice Chamberlain at paragraph 63 said, as is on the slide there, the key question in the present case, Paul, is whether Mr. Paul's collapse from a heart attack 14.5 months after the treatment is capable of constituting a relevant event. And it seems to me that at least on this point, the two were agreed. Master Cook at paragraph 35, the facts of this case are clear. The question is whether the death of Mr. Paul is capable of being the relevant event for deciding the proximity question. Unlike Mr. Justice Chamberlain, Master Cook simply did not, as he went on to say, consider that a trial of the facts was required to answer the question. And I'll touch a little later on, perhaps he was contemplating a subtly different proximity question in that quote. So what is it that prevents the heart attack being the relevant event? Well, for Master Cook, it appears clear that death is too far separated in time from the clinical negligence. And so while the event may have been shocking, there was an absence of proximity in time and space between the negligence and the event. And his paragraph 40 is instructive. It's produced in the slide on detail. And I propose that there's a reasonable amount to unpack, but I propose to do so in singular terms. He says there on the third line to do so, and he's saying that to focus on the death is not an approach. He says that to do so overlooks entirely that there must be a proximate connection between the initial negligence and the shocking event. Now, taken in isolation, that sentence, while there may be a need for a connection between the negligence and the shocking event, at very least in causative terms, and while there is a form of proximity required such that that statement is not in isolation incorrect, it's important to go on through the rest of the quote to clarify the form of the proximity being contemplated in that paragraph, and that arrives in the next section. He says it is this proximity in time and space. So it's apparent, I say, that the proximity being contemplated is not the broader sense of Lord Oliver's essentiality of duty, the neighbour principle. Rather, we're now in the narrower sense of the control mechanism features of proximity in time and space. And it seems to me to be clear that Master Cook is requiring the defendant's negligent act or omission to be close in time to that shocking event, which must be taken to be the shocking event causing the secondary victim's psychiatric injury. Now, he then goes on to say that it was that allowed Lord Oliver to impose the duty of care in Alcock. So a proximate connection, or a lack of a proximate connection in time and space between negligence and event. Well, if we look at the requirements of Lord Oliver in Alcock, and they're there on the bottom third of the slide, there were matters such as personal presence at the scene of the accident or the vicinity and aftermath, physical proximity to the event, a close temporal connection between the event and seized perception, physical propinquity between the claimant and the event, shock sustained by the claimant contemporaneous with the event. He saw that as furnished by the quote of Lord Wilberforce that we've seen, proximity to the accident and hearing of the event. And so what becomes apparent with what Lord Oliver in fact imposed the duty of care with, I say, is he was aligning the accident and event as one interconnected matter. That's what Lord Wilberforce was contemplating. Nothing is said at those stages and in those cases to import a requirement for a temporal connection necessarily between the negligence and the event. Now, the quote then goes on to say that this was described by Lord Dyson in Taylor and A. Novo as a necessary but not sufficient condition of legal proximity. Well, paragraph 27 of Lord Dyson's judgment states, and it's there at the bottom of the slide, physical proximity to the event is a necessary but not sufficient condition of legal proximity. And I take that to mean the proximity between the secondary victim and the event, not between the negligent act and the event. And Lord Dyson went on to consider the proximity as between the secondary victim and the defendant in the separate context of the neighbour principle, rather than by reference to the secondary victim controls. So he then says it's this proximity which has been found to exist in all successful secondary victim claims, including Walters. Well, perhaps that might be doubted by reference to Walters. The focus in the case of Walters was the question of whether an event was capable of lasting 36 hours as a continuing seamless tale. And the second point I would make is while proximity between negligence and the event wasn't the point in Walters, it is notable in Walters that the first negligence, a failure to diagnose jaundice hepatitis, occurred 13 days before the fit arising from it, a period coming closer perhaps to the 3 weeks in Taylor and A. Novo. And he then summarises that it's that lack of proximity that we followed the thread of, which explains why Taylor and Somerset and Taylor and A. Novo failed. Well, to the extent that that might be right, where is the requirement for it? In Taylor and Somerset, the question for the court, said Mr. Justice Old, was whether Mrs. Taylor's involvement, as he'd summarised it, in and within about an hour of her husband's death, brought her within the immediate aftermath. While it was, and it's right that it was said there was no such event here other than the final consequence of progressively deteriorating heart condition, that particular point remains the question at strikeout stage in Paul of whether there had been any actionable damage between negligence and death. And notably, Mr. Justice Old went on to say that even if Mr. Taylor's heart attack could be considered an event to which the immediate aftermath extension applied, the doctor's communication to her of that fact would not come within the extension. And perhaps that oral notification and later visit to the mortuary is as much the point explaining why Taylor and Somerset failed. The issue in Taylor and Novo is perhaps more readily engaged with considering where the event lay. However, in that case, there was a clear event giving rise to injury before the death event that was relied upon, such that proximity to the event relied upon was not found. The Taylor and Novo case was not a single or series of events case. It was seen as a 2-event case with a readily identifiable injury 3 weeks before. So if that is why Master Cook says the event cannot be the heart attack, then it follows, how does Mr. Justice Chamberlain reason that? Well, in the first of 3 reasons he explored as to what might prevent the heart attack being the event, he noted there was no need for synchronicity of negligence in the event, as would seem to be Master Cook's opposite contention. I form the view that seems to me to be correct, but also that a view may depend on how one reads the authorities. And as foreshadowed, this is a tortuous area of law. But it seems to me that in the House of Lords authority, there's no expression of such a requirement for proximity between event and negligence. And indeed, one can draw the powerful implication that while those cases were considering accidents rather than clinical negligence, the tenor of the judgment recognised no essentiality of synchronicity, whether that be in McLaughlin and O'Brien, as we see there, the fact and the consequence, whether it be the observation in Alcock that no case prior to the first instance hearing in that matter had countenanced damages for injuries suffered where there was not at the time of the event a degree of physical propinquity between the plaintiff and the event caused by the defendant's breach of duty. And again, Lord Oliver in Alcock, there is in many cases, as for instance, direct physical injury on a highway accident, an almost necessary coalescence of the twin elements of foreseeability and proximity. But where such convergence is not self-evident, the question of proximity requires separate consideration. Mr. Justice Chamberlain also noted that Taylor and A. Novo, while being a two-accident case, held that recovery would be possible by witnessing the first event of the collapsed racking without consideration of when the racking was negligently stacked, which must be right in my assessment, as the collapse isn't the negligence. The act of doing the stacking or the omission of binding it correctly is the negligence. It has to be right, the collapse isn't the negligence any more than a slip on ice is the breach of duty rather than the failure to ice the path, the action or omission coming earlier. And if one follows that, surely the effect of the negligence which causes the damage is the event. If that is right, what drew Master Cook to an evaluation that there was force in the gap between negligence and shocking event? if one follows his reliance on Taylor and a novo, it seemed to me that in that case, the gap was seen potentially as simply being too long. Paragraph 30 there, Mr. Taylor would have been able to recover damages for psychiatric illness, even if her mother's death had occurred months and possibly years after the accident. This suggests the concept of proximity cannot reasonably be stretched this far. What that seems to lack for present purposes is identification of either A, where does short enough become too long, and perhaps an explanation of how damage generally can be latent for an indeterminate period in many torts. Because it seems to me that Taylor and Novo, which recognised in that same analysis that if the time were sufficiently short, one might say arbitrarily so, then in order to attain the requisite proximity, the secondary victim was in principle able to be outside the presence of the tortfeasor, such as to engage a direct proximal relationship and attendant foreseeability in its face, and yet recover simply upon the notion of being closer in time. So what difference does time make? Whatever the point in Novo, it certainly appears, as held by Mr. Justice Chamberlain, there's no express authority requiring a proximate connection between negligence and shocking effect. And one might wonder whether Master Cook was simply saying in a more direct way that which is implied in a novo, simply too much time had passed from the negligence, or that the focus on the proximity between the secondary victim and the tortfeasor takes primacy and defeats the claim. But is that, in fact, a question of proximity, of foreseeability, or even one of public policy? Nevertheless, what Master Cook stated was in clear terms, and maybe on brief closer inspection, there's an explanation for his more explicit call for proximity between negligence and event. Again, a busy slide, but I simply want to highlight two points. There may be reference to a requirement capable of being implied in Taylor and Novo, the quote at the top there, derived from Taylor and Somerset. Mr. Justice Chamberlain noted the Lord Dyson considering it undesirable to allow recovery months or years after the accident, but that ran from the reasoning that accident cases were the paradigm example. Mr. Justice Chamberlain reasons that this formulation in Novo of paradigm examples allows for non-paradigm cases where there is no accident, but some other form of event, such as in Walters. But if we look a little more closely at that and follow the thread, the language is notable. In Taylor and a novo, paradigm example of the kind of case in which a claimant can recover damages as a secondary victim is one which more or less immediately causes injury or death to a primary victim. There is no acknowledgement or recognition that there is any gap in time. And that flows from Justice Old in Taylor and Somerset, who again was looking at notions implicit in the exception, that being the aftermath exception, cautiously introduced. And he said an external traumatic event caused by the defendant's breach of duty, which immediately causes some person injury or death. Now, it's right, when you look at that sentence and you associate the immediacy with the event, you arrive at the point I argue for. But on the language as appears, it speaks to the breach of duty, which immediately causes some person injury or death. So does that, by looking through the prism of the immediate aftermath, create the inference of an immediacy that is not in fact required? Because the aftermath is not and wasn't a factor for assessment on the facts of Paul, where subject to qualification of the relevant event resolving in favour of the claimants, there is no dispute that the children were present at the scene of a shocking event. Yet Master Cook expressed a focus on death as the first manifestation, overlooking the need for that proximate connection. I'm going to move now to the question as to whether the heart attack was prevented from being the event. Chamberlain considered whether, if there's no need for synchronicity in that form, is there any distinction to be drawn between act in omission. And you can see on this slide, we've gone from busy to rather more quiet. But Chamberlain said not. And it would seem to me that once you say the event can be a separate consequence of the negligence, it would seem less troublesome to have an omission as distinct from an act, provided a requirement prevails for some damage and an event thereafter. It's difficult on its face to see how this disturbs any principle affecting a typical personal injury, non-medical negligence setting. And in a sense, why should it? Where matters are more coincident in time, things are less difficult, perhaps. The challenge being whether the floodgates open on a Walters-type extension. I do wonder, though, whether the question, or whether it's always right, whether rather than asking if there's a difference between act and omission cases, a better question might be, and I say this question need not necessarily trample on the proposition that there's no difference between accident and clinical negligence cases. Is there a difference between almost immediate or delayed consequences cases? To what extent, other than the extent to which the damage is or is not accruing, is there any difference between a couple of examples? Negligent car servicing or laying of rail track, which later leads to an accident, or negligent cladding and insulation choices that later are capable of causing fire, as distinct negligent medical treatment, whether act or omission, that lead to complication or death. In all those cases, do all the material effects not take place sometime later away from the tortfeasor? One might, of course, say the medical treatment starts a chain of events and creates the disadvantage, or that the failure to see damage prevents the cessation of the problem, and this leaves the primary victim instantly worse off. But while that may be the case, as a matter of principle, how different is the negligent failure to remedy a damaged or incomplete railway line? If I lay the HS2 line and then don't attend to it until it opens, and that is negligently done, where is the break in that? Thirdly, in Justice Chamberlain's judgment, there was the central argument for the defendant that the secondary victims couldn't succeed as they were absent from the scene of the tort. The point engaged there is how and when is the tort complete, and that's perhaps rather more nuanced. It really links to a final part of the talk that I'll come to very shortly, and the question of what the position will be going forward in the Paul case, and perhaps more broadly in secondary victim claims. Where and when does the tort crystallise is perhaps another way to put it. At its essence on this particular point, Mr. Justice Chamberlain was of the view that in accident cases, breach and damage are coincident, or we've discussed that. In these cases, the scene of the tort is the scene of the negligence. Carrying forward the assumption that we've discussed for no need for synchronicity with the negligence, that the scene of the tort can only then be where the damage first occurred, he said. And pausing there, that would seem consistent with the facts and judgment in Taylor and A. Nova, where the racking incident was clearly identifiable. That was the damage which first occurred. And perhaps it's not inconsistent with Taylor and Somerset, given the factual finding of culmination of disease, of failure to witness and failure to attend the aftermath. So perhaps at that stage, not as controversial as might appear. And he noted that, or made the argument that while Dryden shows, and the case of Dryden effectively shows that biological changes occurring that aren't manifest can allow a primary victim to ground a claim, it creates actionable damage and noise-induced hearing loss claim in that regard. For the purpose of this application, for the purpose of the appeal of the application, there was no sufficient evidence on the point. This was an argument about strikeout or in the alternative summary judgment. Now, again, in that respect, we might separately posit that language gives rise to further questions. Well, manifest to whom? If not manifest, the damage may still have occurred, engaging the principle previously relied upon, i.e. the first damage was the scene of the tort. Nevertheless, one might also say that the bald assertion of first damage, as opposed to first manifestation, is rather easier to address with less equivocation at a preliminary stage such as strikeout, first manifestation being slightly less prescriptive perhaps. So what then is the way forward, and is the question, where is the event? This is a difficult topic, no doubt, and Paul is a particularly difficult case. I take the view, if nothing else, that the matter is to be assisted greatly by further lay and witness evidence on the condition of Mr. Paul between November 2012 and death. Until that time, it's perhaps a brave call to prefer one outcome over the other, Master Cook's or Mr. Justice Chamberlain's. I say it's reasonably opened to be argued that Master Cook's was the correct outcome, though I think I've indicated in my assessment that the way it was arrived at is perhaps open to question, and was capable of appeal in the way that it was. I also take the view that the decision of Mr. Justice Chamberlain, if it ended there, need not be so controversial, it being right that the case is confined on its facts and on its pleading, and it was heard within the confines of the application. The difficulty, I say, perhaps more greatly, arises in these obiter observations, comments tending to address the period between negligence and what, for the purpose of the application, needed to be the first manifestation. Because having given judgment based on the pleaded case, as again was required, he made those observations that in novo, he said at point A there was something properly capable of description as an event before the heart attack, the racking incident in that case, which coincided with or preceded the first actionable damage. Now, there was nothing in Paul to compare, and as I've said, it was an accident case in the application of that point. He then said, if a stopping point is needed, the most obvious candidate point must be the point at which it becomes manifest or evident. Well, in part, that perhaps speaks to that question of how long is too long. Is there a time frame to be created? But he wasn't prepared to accept that the floodgates will open, saying that the control mechanisms continue to govern the macro level events, he placing the event at the micro level. Had he stopped at first manifestation on the strikeout case, there may have been less discussion about the judgment. After all, again, strikeout, summary judgment. But how readily can either, in such a situation of summary judgment, can the secondary victim show the absence of any prior damage, or the defendant show the existence or recurrence of any prior event, perhaps even with expert evidence, let alone without? So, on the facts of Paul, in the context and confines of a strikeout application, assuming therefore no substantial damage between November 2012 and January 2014, I'm of the view that the decision of Mr. Justice Chamberlain, again in the context of strikeout, appears preferable to that of Master Cook. I pause to just something that maybe something you'd be interested to look at afterwards. I won't go into detail, but there is a case Purchase and Ahmed, which is on appeal from the judgment of District Judge Lum in Birmingham. It has some common principles, not entirely dissimilar facts, albeit this was a negligent failure in Purchase and Ahmed to diagnose pneumonia, where the secondary victim found the primary victim shortly after death. So slight factual difference in terms of the finding. But that case also contemplated the meaning and identification of events, the meaning of proximity, and whether, by reference to Walters on the facts of purchase, there was a continuing event. An interesting case to look at for another view, and to show the difficulty with which these matters are addressed, but a matter which may well be heard concurrently on a leapfrog, perhaps with the Paul appeals. So, if cases such as Paul are able to recover contrary to Taylor and Somerset, well, what does that mean? Do the floodgates open? Well, certainly it may creak the gate further open than closed to individual claimants, but all of which said, it seems to me that it would remain difficult to demonstrate no prior damage, and also to meet the control measures. And there are examples in Shorter, the difficulty in Shorter in showing that there was no damage, where on the facts of that case, biological progression, whatever that may be, was operating from the week prior to the event, which then took place for 2 days surrounding death. Shorter also had difficulty in engaging Walters with a lack of a series of assaults on the mind and subject to the remaining control mechanisms, including in Shorter the difficulties with the fact and consequence becoming known in that case by oral transmission rather than visually. There's an example even in Taylor and Somerset. Let us not forget that the main issue in the case for Mr. Justice Auld was summarised thus: the question for the court is whether Mrs. Taylor's involvement brings her within the immediate aftermath. And it seems to me that Shorter and Renane had pinned down what the event was, but failed on proximity to it, a subtly different question to Paul. Indeed, in Renane, the question seems to be akin to what is required to provide the necessary sudden shock within the specific confines of the hospital setting, and in doing so, recognising the expectation of illness and injury and risk of the same in hospital. Might it then be simpler and cleaner if the defendant's proposition is accepted, and the apparent principle of Taylor and Novo, that the time to assess proximity between the secondary victim and the defendant is at the time of the commission of the tort? Although I say that taking that back to negligence in a clinical setting engages 3 points. One, it's highly unlikely that the primary victim is accompanied in an operating theatre, certainly as opposed to a consultation. Secondly, an omission has no shocking event external to anyone, perhaps. And thirdly, does that mean that no matter how shocking the later event, and while that may start time ticking for the primary victim, the secondary victim boat has already sailed because of the omission? And so, turning finally to considerations on subsequent appeal and analysis of that. On appeal, and it seems to me, hearing it with Purchase and Ahmed may well have some merit. Dryden is perhaps the most striking authority to trouble the claimant's position, and it is perhaps on its face at odds with Walters. Now, I pause briefly to question how much Walters is really the answer for the claimants in Paul, in that its primary form of authority seems to me to extend the time in which the suddenness of shock can operate. In Paul, at least, there's a single shocking event, a point on which there seems to be no apparent discord. Perhaps the main benefit of Walters to the claimant is, in fact, that it also appears to show that the initial negligence occurred 13 or so days before the death, and that's a period of time approaching that of the gap in time in Taylor and Novo, and some damage does appear to have occurred in the intervening period in Walters. There seems to be little to subvert that proposition. Yet, to the extent that Walters might point to the permissibility of arguing a secondary victim claim where there is a separation in time, that has to be capable of outward conflict with Dryden. Given that on the basis that becoming sensitized to a matter short of developing an allergic reaction, the factors in Dryden, sufficed as actionable damage, that case represents authority at Supreme Court level, that anything beyond negligible damage, even where not manifested, is sufficient to crystallize the tort. So is there a way to reconcile these positions, or does Dryden before the Supreme Court in 2018 make Walters in the Court of Appeal in 2002 wrong? On this basis, does it not become sufficiently unlikely that the claimants would be unable to show no actionable damage, such that the defendant's summary judgment application is able to succeed, even if not capable quite of meeting the threshold to strike out? In alighting on the event, the current law to me would seem to be, if an event takes place, even though not shocking, a later shocking event is negative. If the first has a shocking character, that can be enough, and that event seems capable of being made up of a reasonably short sequence of events, albeit in a single event. And in one case, the analogy was of a sports event, and numerous sports events within that event being used by way of analogy. But it seems to me that whether or not one starts first with the assessment of whether the secondary victim and the defendant have sufficient proximity, one can't conclude Taylor and Novo's primary question in that way without determining that according to or by reference to the control mechanisms. Once you do that, the identification of the event relied upon, I say, becomes a central feature by causing you to ask three things. What caused the psychiatric injury for which recovery is sought? Was that cause a shocking one? And was that a or the relevant event operating from the defendant's negligence? That event must, of course, have been caused by the defendant's negligence, and of course would helpfully be as close as possible in time and space to the negligence itself. But there doesn't seem to me to be a formula or an authority defining what that period is. If it is truly the first manifestation, how could either the primary victim or the secondary victim identify it any sooner? And driving remains a difficulty there. But that, I suggest, is the process of the analysis. Is the fact of difficulty in attaching a shocking event to a clinical negligence event not a sufficient control in itself? Any earlier damage would stop a later event being actionable, albeit, of course, Mr. Justice Chamberlain went further and seems obiter to permit some damage, provided not in that manifest way, although that's what makes this particularly interesting. But even then, and once more, the control mechanisms continue to govern the narrow range of the potential claimants. They continue to govern the circumstances, the requisite temporal and physical proximity, and the means of experience. In short, they continue to govern the Alcott measures of who, where, when, and how. They still need to be satisfied. All one has done additionally is establish the event, the what, against which these tests must be read to discrete facts. And so I arrive at the bottom of the slide after an hour together, and hoping that it's not an indictment of the talk. I suggest we perhaps come little further than where we started. If we identify the event, the control mechanisms all remain between the secondary victim and recovery. But is that not the point thus far and no further? Now that concludes the talk. I'm conscious that we've run a little over time. I can't see a question that could be answered in very short order. So I leave open the invitation that I made at the start of the talk today, which is please do feel free to contact me either with a question or literally to discuss, because the one slight tone of regret is that perhaps on occasion this sort of topic benefits from a two-way dialogue. But do feel free to send questions. Again, I remind you that on the website, all of the other Forest Buildings webinars are accessible to you. I understand that a copy of these slides will be sent, and a link to the recording. So all that remains for me to do is to say thank you very much for attending, and I wish you a good evening. Goodbye.